Hello and welcome to this presentation on the single system of law principle that we will be unpacking specifically to see how it assists us with navigating sources of property law in the constitutional dispensation. I'm Dr. Joshua and I will be taking you through this topic in this presentation. Before one can navigate or make a decision around sources of law, which source of law should be relied on and which one should not be relied on, it's important to know the sources that one is dealing with. And in this regard, I refer you back to our previous narration where we specifically unpacked each and every source, the sources that you can currently see on the slide. So just by way of refreshing very briefly, there are multiple sources of property law in South African law, namely the common law that forms the backbone of the law of things for purposes of the day-to-day regulation of interests and rights over things. Legislation that supplements the common law and replaces parts of the common law of things. We also have customary law, which regulates customary and indigenous proprietary relationships. We also have case law or precedent, a source of property law that provides for interpretation and application of not only common law principles, but also legislative provisions and also constitutional law imperatives. And that also helps with the development of the common law. So legislation really has a very I correct myself, case law or precedent has a very broad mandate or function when it comes to what it does as a source of law. And then most importantly, we have the Constitution, which we know is the most important source of property law. The Constitution is not only a source of property law through Section 25, but it is also founding and directing or a direction-giving document for all sources of law. So the sources, each one can and often do constitute its own system of property law. And with this, it's meant that its own regulatory framework exists with specific values that it purports to protect. And each of these systems of property law can have different and sometimes conflicting objectives. Now, in practice, there can be several parallel systems of property law that regulate a particular dispute. For instance, the situation can exist where there is a common law principle or remedy plus legislation plus a provision in the Bill of Rights that regulates the same dispute. So practically what happens then, or what this means, is that where a party wants to litigate an issue, the party would often reach, or rather opt for, the source that gives it its stronger case, or strongest case. And the opposing party will do the same, will also go for the source that it feels like gives it a better chance to win the case. Now often, the parties would then opt for different sources depending on which source with its regulatory framework provides the best or the strongest remedy or protection. And this is naturally because what might make the stronger case for one of the parties will not necessarily make the stronger case for the other party. The effect is that these parties will not be relying on the same source of law, and this is problematic because different sources of law are brought to court to decide the matter on different sources. It could be constitutional sources, it could be legislative measures, it could or provisions, and then these different sources are naturally pitted against each other. So each then have their distinct regulatory environment and system. This includes the fact that the different sources will have different procedures as prescribed by the source's regulatory environment and can have different substantive considerations as well. It can be that, for the one party, it's easy to prove or to meet the burden of proof because of the regulatory framework that they are using working in, and the other party then chooses a different regulatory framework because it might be, and that regulatory framework might be easier for that party to prove its defense rather than relying on or using the same regulatory framework in which the applicant, for instance, is working in. So the effect is that depending on the source of law that is chosen, there are specific results that comes up, and they are therefore different results. So this is problematic because we need to get to a result that promotes the values and rights enshrined in the Constitution, but instead the parallel system often creates a power struggle between sources of property law and rights that promotes, first of all, the status quo, and sources of property law and rights that promotes exclusively transformation. Now, we must be intentional about how we choose the sources we rely on. So this is required. If we do not have an angle of approach to choosing sources that are relied on to protect rights, the parallel systems of exclusive protection of the status quo and exclusive advancement of transformation will remain unexamined and continue contrary to the constitutional vision. In other words, we need an angle of approach that can assist us with scrutinizing sources and testing them against the rights in the Bill of Rights and the spirit, purport, and objects of the Constitution. And that will assist us with determining the most constitutionally appropriate sources to rely on or to litigate with in the event that there are multiple sources that could be relied on. So an angle of approach is crucial. Now, given the issues outlined, let's see what the law says about how we should approach conflicts in sources and the need to maintain a balance between the struggle of the status quo for stability, purposes, and transformation. So the law directs us to the single system of law principle as a starting point. So what is the single system of law principle? It is a principle laid down by the Constitutional Court based on Section 1C and 2 of the Constitution. Now, these sections establishes the supremacy of the Constitution and the rule of law. The case in which these provisions were used to lay down the single system of law principle is the pharmaceutical manufacturer's case. This principle was articulated in paragraph 44 by former Chief Justice Jorgensen as follows. There are not two systems of law, each dealing with the same subject matter, each having similar requirements, each operating in its own field with its own highest court. There is only one system of law. It is shaped by the Constitution, which is the supreme law, and all law, including the common law. And this, you can really include here the common law, the legislation, customary law, case law, etc., all the sources that we looked at in the previous slide. All of them derives their force from the Constitution and are subject to constitutional control. Now, the dicta is clear that when we choose between sources, we should start with the Constitution, and the Constitution should inform all the decisions we make regarding sources. The single system of law principles should therefore guide from or form the basis of the angle of approach that we devise. From the subsidiarity principle, the Constitutional Court, in a series of subsequent cases, laid down further principles. Professor van der Walt coined these principles as the subsidiarity principles, and he also then developed them further. Now, what does the subsidiarity principles entail? What are the nature and character of these principles? The subsidiarity principles consists of two principles and two provisos, and in the next slide we are going to look at the two principles and the two provisos and detail what exactly they entail. Importantly, the subsidiarity principles assists with the promotion of a single system of law and avoids parallel systems being created. Because they assist with the promotion of a single system of law principle, and they allow us to ensure that parallel systems aren't created, it's important also to know that they do not limit the court's powers to interpret, review, and develop the law. So it's not a compulsory, or the principles are not compulsory for the courts to apply, but they can assist the court with promotion of the single system of law principle. And this is really encapsulated in the idea that the subsidiarity principles are a point of departure when determining on which source a litigant should rely to protect a right in the Bill of Rights. In other words, they provide us with a starting point for an angle of approach. The subsidiarity principles are then also supplemented by the desired qualities and unwanted effects test. This test will be unpacked a bit later in this presentation. Now, in this slide, we are going to unpack each subsidiarity principle. And as we've indicated, the subsidiarity principles are really the starting point for when one must determine which source of law should be relied on, where there are multiple sources with their own remedies to choose from. Now, as mentioned also in the previous slides, the subsidiarity principles contain two principles and two provisos. Principle 1 holds that a litigant that avers that a right in the Bill of Rights has been infringed must rely on the legislation enacted to give effect to the constitutional right, and may not rely directly on the provision in the Constitution or the Bill of Rights. So Principle 1 really tells us that it's the specific legislation that was enacted to give effect to a right that must be relied on, and not the right itself. So a litigant is not at liberty to merely go to court and say, my Section 25 right has been infringed, I want a remedy. The litigant must find the legislation that was enacted to give effect to that right and bring the case in terms of the legislation. So the starting point in terms of Principle 1 is that one must rely on the applicable legislation and not directly on the right in the Bill of Rights that is allegedly been infringed. But there's an exception to this principle, which is called the Proviso 1. So the exception to Principle 1 is Proviso 1. Now, the Proviso to Principle 1 allows direct reliance on the right in the Bill of Rights, where the appropriate provision in the legislation is either unconstitutional or inadequate. Reliance on the right in the Bill of Rights in this regard still involves reliance on the legislation, since it must be shown that in view of the provision in the Bill of Rights, the legislative provision is unconstitutional or inadequate. In other words, reliance on the Bill of Rights provision is permissible only if the legislation can be attacked or challenged for being unconstitutional or insufficient. However, reliance on the right in the Bill of Rights in this regard still involves reliance on the legislation, since it must be shown that in view of the provision in the Bill of Rights, the legislative measure is unconstitutional or inadequate. This means that the legislation enacted to give effect to the right will play a pivotal role in this process as well. So this is then the first the first principle and its proviso. Now let's then move on to Principle 2. Now, Principle 2 holds that a litigant averring that a right in the Bill of Rights has been infringed must rely on the legislation, where legislation was enacted to give effect to the alleged infringed right in the Bill of Rights, and that the litigant may not rely on the common law. Now, this principle also tells us that the applicable legislation must be relied on in the situation where there is both applicable legislation and a remedy available in the common law. The exception to Principle 2 is also called Proviso 2. Now, Proviso 2 is the proviso or the qualification or the exception to Principle 2, which requires reliance on the legislation rather than the common law. The proviso to Principle 2 allows for reliance on the common law in certain instances. First of all, where the legislation does not cover the infringement and therefore cannot be relied on. Secondly, where it was not meant to cover the infringement, and thirdly, where it cannot be interpreted to cover the infringement. Importantly, however, it is necessary that the common law remedy or the common law cause of action that is considered here must be in line with the Constitution, or it must be possible to develop it in line with the Constitution. So that is then the second proviso, or the proviso to the second principle. So now that we've looked at what the subsidiarity principles entail, we are going to focus on the following question, specifically what the angle of approach is that should be employed to determine which source is the most appropriate one to rely on to promote the single system of law principle. Now, to answer this question, we use the subsidiarity diagram as an angle of approach. And your starting point on the subsidiarity diagram should be there where it says start here. You will then notice that you have to determine if there is legislation that regulates the dispute. And this is naturally in line with the subsidiarity principles. Think about specifically Principle 1 that requires, and Principle 2 that requires reliance on legislation rather than, first of all, the constitutional provision or the common law rule or remedy that might also be a possible source to rely on. So you will have to determine if there is legislation that regulates the dispute. Your options are post-1994 legislation, pre-1994 legislation, or no legislation. So first, you will then have to assess the possible sources and establish if there is legislation at play. If there's no legislation, you should advance to the no legislation block, which is this one here at the bottom. If there is legislation, you must determine if it is post-1994 legislation or pre-1994 legislation enacted by a democratically elected legislator. So post-1994 legislation enacted by a democratically elected legislator or pre-1994 legislation that was obviously not enacted by a democratically elected legislator. So you must make this determination by looking at the year in which the legislation was promulgated. Now let's assume that the legislation was is post-1994 legislation that was enacted by the democratically elected legislator in the constitutional dispensation. When relying on such statutes, deference should be afforded to the legislator that enacted the statute because it is likely that the provisions of the legislation will promote the purport and objects of the Bill of Rights, thereby abiding by the supremacy of the Constitution. Now, when it is established that it is post-1994 legislation, it must then be determined if the legislation gives direct effect to a right in the Constitution or whether it gives indirect effect to a right in the Constitution. In other words, a right in the Bill of Rights. So legislation that was specifically enacted to give effect to rights in the Constitutional Bill of Rights constitute legislation that is direct post-1994 legislation. This one. You must determine if the statute is direct or not by looking at the long title of the Act or the explanation of the memorandum of the legislation and consulting the relevant Bill of Rights provisions. The focus will fall on whether the legislator intended to give effect to a right, not whether the legislation indeed gives effect to a right in the Bill of Rights. So examples of constitutional provisions that explicitly would sanction the promulgation of legislation to give effect to rights in the Bill of Rights is Section 9, equality, the labor relations section, property section, specifically Section 5, subsection 5 and 9, etc., etc. But also note that all legislation that gives effect to rights in the Bill of Rights, irrespective of whether the promulgated legislation was expressly required by a constitutional provision, will constitute direct post-1994 legislation. The only requirement here is that that the legislation must expressly and directly set out to protect a clear right. Okay. Now, legislation that gives effect to rights in the Bill of Rights indirectly, it's this one here. In other words, indirect post-1994 legislation refers to legislation not specifically enacted to give effect to rights in the Bill of Rights. In other words, the legislation was not enacted with the right of property, for instance, in mind, but does so indirectly or partially. So it gives effect to a right in the Bill of Rights, be it property, section 25, or another right in the Bill of Rights, indirectly or partially. Now, indirect legislation has implications for constitutional rights, such as property rights, and therefore may indirectly affect or protect constitutional rights, such as property rights. An example of this would be the National Credit Act and how it is applied in the context of mortgage foreclosure. So just make a note here that when we get to mortgage foreclosure, specifically under the study unit of real security, that we come back to this point here so you can see how this is illustrated there. All right, so once you have established that this is the type of legislation you are dealing with, in other words, indirect Bill of Rights legislation, then you must consider the subsidiarity principles. First of all, you'll have to determine which principle or proviso will apply, and this will really depend on the circumstances. Now, in terms of principle 1 and 2, you will have to rely on the indirect legislation and not the constitutional provision directly. That is obviously underscored by principle 1, and also not a common law remedy or principle if the situation there is a common law remedy or principle available to the litigant. And this is obviously we see this through principle 2. Now, Van der Walt notes that here the indirect post-1994 legislation must regulate the dispute because it reflects the democratically elected legislators' decision to regulate the dispute through the legislation that it enacted in the constitutional dispensation, irrespective of it not dealing with property expressly. In terms of the subsidiarity principle 1 and 2, the litigant will not be able to choose the common law remedy or section 25 just because it explicitly gives effect to his or her property right, whereas the indirect post-1994 legislation does not explicitly give effect or mentions or include its property right. The litigant will have to rely on the indirect post-1994 legislation still. This will be the case unless the situation triggers the provisos, in which case the provisos could allow for reliance on section 25, but obviously in this situation then to challenge the legislation or the common law to fill in gaps where the legislation wasn't intended to cover the specific issue. So this will have to be determined on the factual scenario and given the specific legislation that is dealt with. So the legislation will have to be perused to determine if section 25 challenge in terms of proviso 1 it is an option, and also whether if there's an common law alternative that actually fills a gap, whether there is a gap created by the legislation that the common law can fill. Alright, so once you have established that the legislation is direct legislation, okay, so we're now moving from indirect legislation to direct Bill of Rights legislation, then you must determine if the legislation is property legislation or non-property legislation. Now, when we're dealing with property legislation, we are really referring to or dealing with legislation that was specifically enacted to give direct effect to section 25 of the Constitution and other property related constitutional provisions. So when we say provisions that were specifically enacted, legislation, sorry, that was specifically enacted to give effect to Section 25 of the Constitution, so the Property Clause. We're talking here about the Land Reform Labour Tenants Act of 1996, the Extension of Security Tenure Act of 1997, the Interim Protection of Informal Land Rights Act of 1996 as well, etc. And when we're talking about other property-related constitutional provisions, in terms of which the legislation was promulgated, we are referring to something like the Housing Act of 1997. So there are a number of legislative measures or statutes that constitute direct or direct Bill of Rights legislation or direct post-1994 legislation that is specifically property legislation. Now, if we are assuming that the legislation is property legislation here, so we're dealing with something like the Prevention of Illegal Eviction from Unlawful Occupation of Land Act, or the Housing Act, we then have to determine if it is complete property legislation or partial property legislation. Now, importantly here, in South Africa, there is no single statutory legislation or provision that completely regulates property law, but there are various legislative provisions that regulates property partially, or stated differently, various specialist application of property law can be found in statutes, and this we call partial property legislation. Thus, we do not have complete property legislation, we rather have partial property legislation. So this means then if we are dealing with property legislation, it will always be partial property legislation that we deal with. So now, once we have established that the legislative measure is indeed partial property legislation, it will we will then have to consider the subsidiarity principles to determine how they will then apply to this legislative measure. So the question is, which principle or proviso will apply? Now, in terms of principle 1 and 2, you will have to rely on the property legislation enacted to give effect to property law or the property rights, and not the constitutional provision directly. And that's obviously principle 1 stated there, and also not on the common law. We see that through principle 2. So this would mean that after looking at principles 1 and 2, we note that the partial property legislation is the source that has to be relied on, even if there is a property constitutional provision, and even if there is a common law remedy or principle that could potentially also apply. So the provisos will only come into play if the legislation is insufficient or unconstitutional. This is in terms of proviso 1 that allows direct reliance on the constitutional provision in this specific circumstances, or if the legislation was not meant to cover the dispute. And we see this this being allowed through proviso 2, which allows reliance on reliance on the common law for the development of the common law, or even just the use of the common law where there's a gap, for instance. But as point of departure, the principles would then indicate that the legislation must be relied on unless the circumstances and reading of the legislation indicates that there are gaps that was never intended to be filled by the legislation, or that the legislation might be arbitrary. And on that point, or the legislation might be an arbitrary deprivation of property. Now, on that point, when proviso 1 would then be triggered, you would note that there's a link with the desired qualities and unwanted effects test that we will do later on in this presentation. But just note that, and whenever you think about the potential application of proviso 1, meaning challenging the legislation for being unconstitutional or insufficient, there is definitely something that we'll have to say about the desired qualities and unwanted effects test there. All right, so now let's move back to the diagram. Now, suppose the legislation constituted direct post-1994 legislation, but constituted non-property legislation. What then? So we are talking now about direct Bill of Rights legislation but non-property legislation, what do we do then? The diagram shows that direct Bill of Rights legislation also includes non-property direct legislation. This refers to legislation that was specifically enacted to give effect to a right in the Bill of Rights other than Section 25 of the Constitution and other than property-related provisions in the Constitution. And examples of this type of legislation, non-property legislation, is Pepuda, Paja, and Paya. It's a promotion of Administrative Justice Act and promotion and Pepuda, the equality legislation. So once you have established that this is the type of legislation you are dealing with, in other words, non-property legislation, then you must also consider the subsidiarity principles. So again, which principle or which proviso will apply, what is the application of the principles, and the application of the provisos tells you about what the most appropriate source of law is in the situation or circumstances. Now, in terms of Principle 1 and 2, again, you will have to rely on the non-property legislation enacted to give effect to the rights in the Bill of Rights and not on the constitutional provision directly. Again, this is in terms of Principle 1, and also not the common law remedy or principle that might also find application. This is we see this through Principle 2. Again, in this context, Van der Walt notes that here the non-property legislation must regulate the dispute because it reflects the democratically elected legislators' decision to regulate the dispute in this way. In terms of the subsidiarity Principle 1 and 2, then, the litigant will not be able to choose the common law remedy or Section 25 just because it explicitly gives effect to his or her property right. It will have to rely on the non-property legislation. This will be the case unless the situation triggers the provisos, in which case the provisos could allow for reliance on Section 25, but to challenge the legislation or the common law to fill the gaps in if there are any gaps. But again, the specific legislative measure, the non-property direct legislation, will have to be scrutinized. Now, if we go back in the diagram, we will also note a possibility is that the legislation might be pre-1994 legislation. So we're back here at the pre-1994 legislation. And this legislation obviously predates the democracy, our democracy. Now, when we rely on such statutory provisions, we must approach them with suspicion or caution, and we must definitely be attentive when we apply it. Why? Because it is likely that these type of statutes may not demonstrate the desired features and that we want to promote in the constitutional dispensation, and it might actually have some of the unwanted effects that we do not want to see in our constitutional property system. In other words, it's possible that these pieces of legislation do not reflect the supremacy of the Constitution, so it will probably be necessary to bring them in line with the Constitution to promote the single system of law principle. So now, since the Constitution did not exist pre-1994, this type of statutes cannot directly give effect to a right in the Bill of Rights. Thus, it's not possible for provisions to give direct effect to the rights in the Bill of Rights. But it is possible by coincidence, perhaps, that provisions in pre-1994 legislation gives indirect effect to constitutional provisions. And that's why we have these two sub-categories here. Partial substantive legislation and purely technical partial legislation, but they will always be indirect. All right. So we will therefore have to determine if the legislation does give effect to a right in the Bill of Rights indirectly. But because of its enactment date, such legislation will unavoidably be partial and either technical or substantive in nature. Now, partial substantive legislation refers to legislation that covers parts, not all, property law that is not intended to give effect to rights in the Bill of Rights because of its promulgation date. Whereas partial technical legislation refers to legislation that partially regulates property law and that is highly technical, so that the reformer's purpose or potential reformer's purpose thereof is hard to determine. Okay. Now, how do we then navigate or evaluate these sources in view of the subsidiarity principles? So while it will be difficult to justify an extended application of the subsidiarity principles because it was not enacted by, or the legislation was not enacted by a democratic legislator, and obviously, or definitely rather, not inspired by the Constitution, it should still be consulted. So the principles, the subsidiarity principles, should still be consulted as a principled point of departure to prevent fragmented and parallel systems of property law coming into being, and to also ensure that the legislation, the pre-1994 legislation, is scrutinized in view of the Constitution. Now, if the legislation is partial, substantive, or technical pre-1994 legislation, the subsidiarity principle should be applied as follows. So Principle 1 will tell us that the legislation must be relied on and not the constitutional provision. And this will obviously ensure that the pre-1994 legislation is scrutinized by a court. So if there are provisions, things in it that indicates that it's unconstitutional, that can be looked at. Principle 2 tells us that legislation must be relied on, not the common law. This also ensures that pre-1994 legislation is scrutinized and that specific law is relied on rather than general principles of the common law. Proviso 1, if we then look at Proviso 1 in view of the pre-1994 legislation, if it is found that the legislation is not sufficient or unconstitutional, the court will be enjoined to interpret the problematic provision in line with the Constitution or to strike it down. Now, courts will give effect to the interpretive obligation to ensure that the pre-constitutional legislation aligns with the Constitution. The work that Proviso 2 then can do can be described as follows. So if it is found that the legislation is not meant to cover the dispute, or it cannot be interpreted to cover the dispute, then the common law can be relied on. And this will only be triggered if Principle 1 and Proviso 1 cannot be relied on due to the circumstances, or due to the circumstances, which includes the ambit and the scope and the content of the legislation. Now, the last part of the diagram refers to the situation where no applicable legislation exists. In other words, this one here, the bottom. The function of the subsidiarity principles in these circumstances are to focus on and scrutinize the common law remedies and institutions in view of the Constitution, with the aim of constitutionally inspired developments and amendments. So then, with that in mind, then how would an application of the subsidiarity principles look in this context, more or less? So they will definitely apply, although there's no legislation. But the implications of there being no legislation that regulates the dispute is that Principle 1 will potentially will not apply as a point of departure. Principle 1 will not apply. Principle 2 will not apply. Proviso 1 will not apply, and Proviso 2 would actually then come in and do some work. So because there's no applicable legislation, the analysis will start with the common law and consider development of the common law to cover the issue where the common law does not cover the issue altogether. And if there's a gap in legislation that can be filled by the common law, then the point of departure would be the same. So the court will have to look at then the development of the common law. So the application of the subsidiarity principles and the articulation of the sources of property law brings us to the point where we realize we should have a principal starting point or angle of approach. So thus, the principles constitute a starting point. This brings us to the second part then of the angle of approach, which involves Section 39 of the Constitution, and specifically ensuring that the result of the subsidiarity diagram with the principles promotes the characteristics of a property law system for a post-apartheid South Africa.